In August 2022, the Indian in August 2022, the Indian government did something governments rarely do. After 4 years of drafting, committee review, and public debate, it stood up in Parliament and withdrew its own data protection bill, scrapped it entirely. 81 amendments had been proposed to it, and the government decided starting fresh beat patching. Critics called it 5 wasted years. The government called it a reset. 12 months later, a shorter, simpler, very different law passed both houses in under a week. Today, the full journey from a Supreme Court judgment to the DPDP Act 2023 and why knowing what was dropped along the way tells you exactly what to watch in the years ahead. You're listening to DPDP Daily. I'm Hamid Singh Kapoor. I've spent my career running large programs and portfolios, the discipline of making complex things actually happen, and for the past few years, I've brought that discipline to India's data protection law. I wrote the DPDP Act Compliance Handbook, from law to ground reality, and this show is that book opened up one episode at a time. If you're new here, the 30-second background: in 2023, India passed its first comprehensive data protection law, the Digital Personal Data Protection Act. In November 2025, the government notified the rules that make it operational on a phased clock that runs to full enforcement in May 2027. Together, they decide what every company, hospital, school, app, and shopkeeper in this country may do with your personal data and what you can demand when they get it wrong. 15 minutes a day, no jargon, real answers. Let's get into it. Pick up the story where yesterday's episode ended, August 2017. The Supreme Court has declared privacy a fundamental right, and the government has an expert committee in place under Justice B.N. Srikrishna, a respected retired judge of the Supreme Court, to design the framework. A white paper arrives in late 2017, inviting the country to debate the shape of the law. And in July 2018, the committee delivers its report with a title worth remembering: A Free and Fair Digital Economy, Protecting Privacy, Empowering Indians. The Srikrishna blueprint was ambitious and unmistakably rights forward: an independent data protection authority with rule-making and enforcement muscle. A layered architecture with heightened protection for sensitive personal data, health, biometrics, financial data, and more. Meaningful limits on the state, data localization requirements, penalties scaled to turnover. If you know Europe's GDPR, you'd recognize the family resemblance adapted for India. The government took that blueprint and produced the Personal Data Protection Bill 2019, introduced in Parliament that December, already softened in places from the committee's version, particularly on government exemptions, which drew a sharp public objection from Justice Srikrishna himself. The bill went to a Joint Parliamentary Committee, and then the pandemic swallowed the calendar. The JPC finally reported in December 2021, proposing dozens of changes, including a controversial expansion to cover non-personal data, and the bill emerged from committee larger, more complex, and satisfying almost no one. Industry found it unworkable. Civil society found the state exemptions alarming. The government, reading the room, withdrew the whole thing in August 2022. What followed was a philosophical pivot, and this is the part I want you to really absorb because it explains the law you now live under. 3 months after the withdrawal, in November 2022, the government published a new draft, the Digital Personal Data Protection Bill. It was strikingly short. The 2021 committee version had ballooned toward 100 clauses of dense prescription. The new draft ran to a few dozen, written in plain language, with the detail deliberately pushed into future rules. The design philosophy had flipped from a comprehensive European-style code to a lean framework law, principles in the statute, machinery in delegated legislation. And in that pivot, specific things were dropped. The separate category of sensitive personal data, Gone. The Act protects all digital personal data at one level. Hard data localization, gone, replaced by the blacklist approach to cross-border transfers we discussed in episode 1. The powerful Independent Data Protection Authority, replaced by a leaner data protection board appointed by the government, focused on adjudication rather than rulemaking. Compensation for individuals, gone. Enforcement flows through penalties, not private damages. Non-personal data, dropped entirely. Some additions traveled the other way. Duties on data principles with a penalty for frivolous complaints. That two-way accountability we covered earlier, rare among world privacy laws. Voluntary undertakings as a settlement mechanism. And the consent manager concept matured into a registered, regulated institution. One drafting story from that final stretch captures the whole process in miniature. The November 2022 draft contained a concept called deemed consent, situations where your consent would be presumed from circumstances. Commentators pounced. Presumed consent, they argued, is how consent dies, a category that starts with medical emergencies and quietly grows to swallow everything. The government listened, and in the 2023 Act, the concept was renamed and restructured as legitimate uses, a closed list of specific situations where processing may proceed without consent, shorn of the fiction that you had somehow agreed. Same practical territory, honester architecture. It's a small story, but it tells you two useful things. The consultation process, for all the criticism, did move real text, and the legitimate users list you now comply with was born narrow on purpose, which is exactly why I keep warning against stretching it. There's also a practical discipline that falls out of the framework law design, and I want to hand it to every compliance owner listening. Because the Act deliberately delegates detail, the law is not a document you read once. It's a stream you subscribe to. A well-run program watches 4 channels on a standing basis. Gazette notifications from the government which activate provisions and designate classes of entities, the rules and their schedules which carry the operational detail. Publications of the Data Protection Board which will supply standards, procedures, and eventually precedent, and sectoral regulators layering their own requirements on top. Assign the watch to a named person, give them 30 minutes a week, and have them log what changed and what it touches in your organization. Most DPDP surprises won't come from the Act. They'll arrive by notification on a Tuesday, and the organizations that read Tuesday's Gazette will simply be months ahead of those waiting for the news cycle. After a final round of consultation, the bill entered Parliament in August 2023 and passed both houses within days, receiving presidential assent on the 11th of August 2023, 6 years from judgment to statute. Then, and this trapped many observers, 2 more years of silence until the rules arrived in November 2025 and started the enforcement clock. The full arc, Puttaswamy to full enforcement, will span nearly a decade. So what should you take from the journey beyond the history? 3 things. First, read the Act as a deliberate minimalist choice, not an unfinished one. Where the statute is silent, no sensitive data tier, no compensation right, that silence was chosen twice after louder alternatives were drafted and discarded. Arguments that assume the missing pieces will quietly return misread the design. Second, the framework law structure means the action never stops. Because the statute pushes detail into rules and notifications, the law you comply with will keep growing. Board publications, government notifications, SDF designations, sectoral overlays. That's why a daily podcast about one act isn't a strange idea. The act is the trunk. The branches are still growing. Third, the dropped ideas are the watch list. Sensitive data protections, compensation for individuals, stronger limits on state exemptions. These didn't lose the argument forever. They lost a legislative round. They live on in academic criticism, in pending constitutional challenges, and in comparisons with global regimes. If the DPDP framework is ever amended or judicially reshaped, it will most likely be along one of these old fault lines. Knowing the legislative history means you will recognize the tremors early. Tomorrow, we shift from history to structure, the full cast of characters this law creates, from data principle to the board itself, and how the roles fit together. That episode is the skeleton key for everything after it. That's today's episode of DPDP Daily. If it made this law a little clearer, do one thing for me. Send it to one person who needs it. That's how this show grows. Everything I covered today, with the templates, checklists, and audit frameworks behind it, is in my book, the DPDP Act Compliance Handbook, From Law to Ground Reality. And I post one practical DPDP insight every morning. Find me on LinkedIn and on X and Facebook as well under Harmeet S. Kapoor. One important note, this is education, not legal advice. For decisions about your organization or your rights, take proper professional advice on your specific facts. New episode every day. I'll see you tomorrow.